Hi, everyone. Welcome back for the last lecture video for this week. We're still talking about defenses, and specifically, we're talking about self-defense today, okay? So I'm going to share my PowerPoint with you, and we're going to work through the self-defense analysis, okay? So when we left off, we were talking about generally criminal defenses and some background information about criminal defenses. And then we were specifically talking about the justification defenses. So just as a reminder, these are the 5 things you need for criminal liability that we've said over and over and over. We covered conduct the last 2 weeks. This week we're in justification. And then we said these are the 3 justification defenses: necessity, consent, and self-defense. So in the last lecture, we talked about necessity and consent and the legal requirements for them. This week, we're going to be talking about self-defense. So just keep in mind, when you're talking about defenses, you're not talking about keeping the prosecutor from pressing charges. You're talking about the prosecutor charging the person and then the defendant raising this defense to the jury so that the jury doesn't find them criminally liable and actually punish them. Okay, so that's what we're talking about with all defenses. Prosecutor is probably going to go ahead and prosecute. Then you have the defenses, which are hopefully going to convince the jury not to find you criminally liable. The other thing that's important to remember with all of them is there's multiple steps in the analysis for defenses. The first one is, can you meet the legal standard to even present the defense to the jury? That is going to be made by the judge. So prior to the trial, there's going to be a little hearing called a motion in limine hearing. And the defense is going to try to convince the judge that there is enough evidence to present this defense to the jury. So that's the first thing. If the judge decides, yes, there is enough evidence to present the evidence to the jury, then you can, and then it's up to the jury to determine whether or not they believe that defense and find the person not criminally liable or acquit the person. Okay, so the last defense that we want to talk about is self-defense. So self-defense is the idea of kill or be killed. That's self-defense, okay? So when you need to defend yourself for some reason. Now, so let's talk about what the definition is, so then we can get into the legal test, because the definition actually sets out many of the requirements for the test. So the definition of self-defense is the use of reasonable force against an aggressor by one who reasonably believes it's necessary in order to avoid imminent bodily harm. So we're going to go through this definition step by step, and we're going to talk about each of these requirements that are necessary for a defendant to try to raise self-defense. So some of the key words we're going to talk about: reasonable force. What's reasonable force? Aggressor. Who's the aggressor? Reasonably believes it's necessary, so it's imminent. You believe it's necessary to stop the force, and imminent, meaning it's going to happen right now. Okay, so those are some of the requirements. So let's first start by talking about when can you actually use self-defense. So the first requirement is you have to legally be present where you're at. So a lot of times people will say, oh, somebody broke into somebody's house and they were shot and they said self-defense. Well, no, you can't do that. If you are somewhere you're not legally allowed to be, you are not allowed to claim self-defense. You can only claim self-defense if you are legally where you are at. The next thing is you have to reasonably believe that it's necessary. So given the facts and circumstances surrounding the occasion, you have to believe that it's reasonably necessary to use some level of force to protect yourself. And it's reasonable. Groups of people would agree with you on that situation. It has to be imminent. So imminent danger means it's going to happen now. You are not allowed to claim self-defense for something that could happen in the future. That's not self-defense. So self-defense only exists for what's happening right now. It has to be unprovoked. So if you are claiming self-defense, you cannot be the one that started it. You're using it for prevention to prevent somebody else from harming you. You cannot be what we call the initial aggressor. You can't be the one that actually started it in the first place. If you're the one that started it or provoked it in the first place, then you lose your ability to claim self-defense. And the last thing is it has to be proportionate. You have to use a proportionate amount of force compared to the force used against you. So we're going to get into a lot of these in a lot more detail. So the first one is it must be necessary. So it means you have to honestly and reasonably believe that the danger is imminent, it's just about going to happen. You have to reasonably and honestly believe that you need to use force, because if you don't, you're going to be harmed in some way. So you need to use some force to fend off the force against you. And you need to use the amount of force that you actually used. You weren't using too much, you weren't going above and beyond, you're using the exact amount of force that was necessary to stop the force to be used against you. So that's the first thing. And you have to have honest belief. If there's evidence that shows you're just making this up as a defense, the judge is not going to allow it to be used. Now, we also said you cannot be the initial aggressor. So you must be the non-aggressor. You cannot be the one to start it. So self-defense is only available if it's an unprovoked attack. If you did anything to provoke the attack, then you lose self-defense. So when you're analyzing these situations, you always have to look at who started it. If the person who started it is trying to claim self-defense, it's not going to be permitted. The judge will not allow that person to claim self-defense at trial. There's another requirement of the need to retreat. Generally, the idea is you can only use self-defense if it's necessary and you cannot escape it in another way. But if you can turn around and get out of the situation without using any force, you are required to do that. There is a need to retreat. You are required to retreat. Now, if retreating puts you at a greater risk of harm, then you don't have to retreat. So I always use the example, if I'm in a closed room and the person attacking me is coming from the doorway and there's only one door and the only way out is to jump out a 10-foot window, well, clearly I can't retreat because that's going to put me at a greater risk of death or serious bodily harm. But if somebody's in the room and I can just turn around and walk out the door and shut the door, then I have to do that. So if I can retreat without hurting myself more, I need to retreat. There's a retreatment requirement for self-defense. Now, the courts have been a little more lenient on this. Like, what if you both live in the same house or you're both there at the same time, live, roommate or something? They don't say you need to retreat in those situations. Okay, so if you both legally live there, you don't have to retreat. Now, what's interesting is Florida has what's called the stand your ground law. Basically, what it is saying is you never have to retreat, ever. So they still have all the other requirements. You can't be the initial aggressor. You have to believe in imminent harm. You only can use force that's necessary, but you don't have to retreat ever. So if you're standing there and you could turn around and walk away and get out of the situation, you don't have to do that. You can stand and fight if you want to. So the question is, what do you think about that? What do you think about stand your ground laws? Do you think you should have the requirement to retreat? There's an argument that it just leads to more fights and more violence if the person's not required to retreat. And do we want to encourage that? And the other thing is, well, I should just be able to stand my ground and fight. I'm not a coward. I shouldn't have to retreat. So there is a battle both ways. There's just a few states, though, that don't have a retreat requirement, and Florida is one of them. Now, there is an exception to the castle rule. And so there is one exception to the retreat rule. It's called the castle exception. If you're in your home, you are never legally required to retreat. So what the law says is your home is your castle, so you never ever have to retreat from your castle. You can stand and defend your castle. So that is one time you never have to retreat. You do not have to retreat if you're inside your home. Now, most of the states require entry into the home. So just trespassing on curtilage is not going to be enough for this, okay? So curtilage is the land immediately surrounding your home. That's curtilage. If people are trespassing on your curtilage, that is not enough for you to use self-defense. And there is no castle exception for that. So there needs to be some crossing the threshold into the actual home before the castle exception actually kicks in. Now, there's an exception, another exception to the retreat rule. So we said you cannot be the initial aggressor, right? So you cannot be the one to start it. But if you are the one that starts it and you try to completely withdraw, you try to get out, like I changed my mind, no, I don't want to fight you anymore. And you try to withdraw, but the other person keeps coming and now they are attacking you, even though you tried to stop it. You may get your self-defense back. And that's called the withdrawal exception. So the initial attacker attacks, then says, no, I changed my mind. I'm sorry, I don't want to, backing up, trying to escape, trying to withdraw, trying to get out of the situation. And the person they initially attacked keeps coming, then they may be able to reclaim self-defense because they tried to get out of the situation, but they weren't able. Now, another requirement we talked about with self-defense is the amount of force that is used must be proportionate to the amount of force being used against you. So if you're claiming self-defense, you can only use reasonable amount of force, and a reasonable amount of force is proportionate force that's being used against you. So somebody comes up and punches me in the face, that would cause me physical pain, physical injury. That was physical force. So I can use anything that would be physical force back, okay? Now, if somebody came up with a knife and was gonna stab me, that's deadly force. So I can use anything that would be deadly force back. So it's not weapon. Sometimes people get confused and they think it's weapon per weapon. So a knife, you can only use a knife back. No, it's what can that knife do? The knife can cause you death, so you can use something back that could cause death. So you could use a gun back. So you think about what is the amount of force going to do to the person? Is it going to physically hurt them? That's physical force. Is it likely to cause death? That's deadly force. So the amount of force being used back against the person has to be equivalent or proportionate to the force that was initially used. If you raise it, if you use, so if you were originally attacked with physical force and you return it with deadly force, you lose self-defense. You cannot escalate the force to a higher level. You only get the amount of force that's being used against you. So let's start with the analysis. So I printed out a guideline for you. I highly recommend that you look online and print it out and have it with you when you do your homework and on your exams. It's a really good step-by-step way to make sure when you're doing your self-defense analysis that you hit all of the requirements, because there's lots of pieces to it. So you want to make sure you go through each of the requirements. So the first question is, who is the aggressor? Okay, so is it self-defense against an aggressor? So when you read the scenario, who is the initial aggressor? If the initial aggressor is the person claiming self-defense, they lose self-defense. You cannot be the initial aggressor. And it doesn't mean the initial aggressor of physical force necessarily. You can verbally be very aggressive towards somebody and make them fear that you're going to hurt them with your words. That's enough to be an initial aggressor, okay? So who started it? If the person claiming self-defense is the one that started it, they lose their self-defense. They cannot claim self-defense. But then you still have to ask yourself, does the withdrawal exception apply? So even if they're initial aggressor, did they try to get away? Did they try to stop it? And the person kept coming. If that's true, they may get their self-defense back. Second, does the retreat rule apply? So did the person or could the person retreat, or should the person have retreated? And then don't forget about the castle doctrine. If it's their home, they don't need to retreat. So that needs to be part of your analysis if you're talking about a home. Was there reasonable belief that there's imminent bodily harm would occur? So what in the facts and circumstances tell you, did they believe that there was harm immediately that was going to occur? And what level of force was used, physical force or deadly force? Did one of the parties escalate the force? If so, who? And if you're the person that escalates the force, then you lose your self-defense, okay? So this is the first part of the analysis. So let's put it into action. So Joey's standing on the street. Bob approaches him and accuses him of going to Bob's boss and complaining, which gets Bob fired. They exchange words and Bob swings and punches Joey in the mouth. Joey then pulls out a knife and stabs Bob. Okay, so let's look at the analysis. The first question is, who is the aggressor? Who is the self-defense against? So who started it? So if you read this scenario, who do you think started it? Hopefully you say Bob. Bob starts it, okay? So who is claiming self-defense? Joey. Joey wants to use self-defense. So since Bob is the initial aggressor, can Joey use self-defense? So far, so good, okay? He wasn't the initial aggressor, so we don't have to apply the withdrawal exception. Does the retreat rule apply? Okay, so the next question is, did Joey have to retreat in this situation? We don't know totally. They're on a street. Maybe he could have turned and walked away. Maybe he would have been able to get away. We don't really have enough facts to make that conclusion. So we would have to find out a little more to know if he could retreat. Did Joey believe that there was a reasonable belief that he would suffer imminent bodily harm? Well, if we go back to the scenario, Bob swings and punches Joey in the mouth. So did he have reason to believe that he was going to be harmed? Yes, he was harmed. He was punched in the mouth. And the last part, reasonable force. So we have to go back to the scenario. What level of force was being used against Joey? Well, he was punched, so that would be physical injury. Now, what level of force did Joey use back? He takes out a knife and stabs him. That's deadly force. So we had physical force met with deadly force. So who escalated it? Joey. And Joey's the one trying to claim self-defense. Joey will lose his self-defense. So when we go in front of a judge and we want the judge to make a determination, can Joey raise self-defense at trial? The judge is going to say no, because the judge is going to say, you don't even meet the basic requirements for self-defense. We're not going to allow the jury to hear it because you don't even meet the legal standard for self-defense. Okay, so I just wrote it out. Who was the aggressor? Bob. No need for withdrawal. Does the retreat rule apply? Maybe. We don't know for sure. Was there reasonable belief that he would be harmed? Yes, he was punched. Reasonable force? Bob used physical force. Joey escalated it, so Joey loses his right to self-defense. So when you're doing these analyses, you should answer the questions just like this. You should go through them and answer them just like this, because then it shows that you covered the entire analysis. Okay, so now you try one. A son threatens to shoot his father with a shotgun. The father went to the neighbor's home and borrowed a shotgun, returning to his son. The son tells his father to stop, but the father shoots anyway. The son then turns and runs, and the father pursues him. The son then turns and shoots his father, killing him. Can the son use self-defense? So this is your analysis. So these are the questions you're going to go through and answer. So stop the video, try to go through the analysis and see what your conclusion is. And then when you're ready, start the video and we'll talk about it at the end. Sorry. Okay, so the first question is, who is the initial aggressor? So in this scenario, the son is the initial aggressor, right? So you would say the son loses their self-defense. But if it is the initial aggressor, does the withdrawal exception apply? So in this case, did the son try to stop, try to withdraw, and then was still attacked by the non-aggressor, and therefore does the son's self-defense kick back in? Yes, possibly. He does threaten it, so he's the initial aggressor. But when he tries to stop it and try to back off, the father then attacks him with deadly force. So then the son tries to retreat, but is still pursued. So the judge could rule that he gets his right to self-defense back under the withdrawal exception. Does the retreat rule apply? Well, he tried to retreat. He tried to run away. So that's not going to affect his self-defense. Did he reasonably believe he was going to suffer imminent bodily harm? Well, yeah, the father is pursuing him and shoots at him. So you could say he did believe it. And then what level of force did the father use? The father's shooting at him. So he shoots back, deadly force with deadly force. That's okay. So the real issue is whether he gets it back with the withdrawal exception. Okay. Now, what about this? Can you set up an automatic device to activate when your home is unoccupied? So this was a case where somebody's garage kept getting robbed over and over. And the guy got so mad, he kept getting locks and changing them. And he couldn't get them to stop breaking into his garage. So he sets up a spring-loaded gun. So when somebody opens the door, the gun would shoot and it would hit the person that was trying to break into his garage. And the court had to decide, are you allowed to do that? Can you use deadly force to protect property? So it's not protecting a person in this case, it was just protecting a property. And the court said no. Protecting property is never a justification for killing another person. So you can't use deadly force ever to protect property. Now you may be able to use some physical force to protect your property, but you're never ever going to be permitted to use deadly force. The court is never going to say property is worth more than a person's life. So don't ever claim self-defense if it's or deadly force self-defense if it's used to protect property. Okay, so now we need to add one thing to the analysis. We are allowed to use self-defense to defend other people. So if I see somebody being attacked, I am allowed to use a reasonable amount of force to defend those people. I'm allowed to do that, okay? But there is one rule that you have to follow, and it's called the alter ego rule. The alter ego rule says you're only allowed to use the amount of force that the person you're defending could use. So I always think of this sort of like the movie Ghost. I don't know if you've ever seen the movie Ghost, but Whoopi Goldberg, she can talk to dead people and they suck into her body and they speak to their loved ones through her mouth. And I kind of think of that when I think of defense of others or alter ego. So alter ego means if I'm defending somebody, I only get the right to defend them to the extent that they themselves would have had. So if they are the initial aggressor, or if they're escalating force and they lose self-defense and I come to their rescue, I don't have self-defense either because I only get what they would have had in the first place. Okay, so I added that to the top of your analysis. So if you were wondering why your analysis looks different, because that's the top part. We just hadn't covered it yet. So the first question you're really going to ask yourself is, who is being defended? Are you defending yourself? If you're defending yourself, you just jump down to the first question, who's the aggressor, okay? If you're defending somebody else, then you have to use the alter ego rule, and you have to do the rest of the analysis in the eyes of the person that was defended, not the one that is defending, okay? So if you were going to somebody else's defense, you go through this analysis based on the person you jumped in to defend. And if they lost their self-defense along the way, you don't have it either, okay? So if I see somebody being attacked and I jump in and clunk the guy over the head with a rock, and it later comes up that the first aggressor was the person I was defending. They're the ones that hit the other guy and the other guy was trying to just defend themselves, but I didn't see that, I just jumped in. The person I clunked over the head with a rock was the person that was initially being attacked. And so the person I was defending was the initial aggressor. Since it was the initial aggressor, they don't have self-defense. And guess what? Now I don't have self-defense either. So the alter ego rule would affect that person's ability to use self-defense. So it's always very important, if you're jumping in to defend somebody, make sure that they actually have self-defense, because if they don't, you don't have it either. Okay, so I posted this song, Goodbye Earl, and it's just a fun way to do this analysis. So listen to Goodbye Earl, and then you would do a separate analysis for each person. first for Wanda, then for Marianne. So first you have to decide, would Wanda have self-defense? And then you would need to determine, would Marianne have self-defense? I'll give you a hint. Marianne's self-defense claim is going to depend on whether or not Wanda had self-defense, because Marianne is defending Wanda, so you're going to have to apply the alter ego rule, okay? So try to think through it and think what you see, because this is going to be very, very similar to your homework for this chapter. Okay, so you'll start at the top and you'll work all the way through the analysis. Now, a couple other things I want to talk about. First is battered woman syndrome, or sometimes they call it battered child syndrome. This is when a woman or a child claims self-defense, that they have been a victim of abuse for a long time and that they are using force to defend themselves. The problem is, a lot of times the woman or the child uses force at a time when force is not being used back. Because when they're actually being attacked, they can't defend themselves at that point. They probably physically don't have the ability to do it at that point. So they wait for a time when the batterer, the bad person, is not paying attention or not aware, and that's when they attack. But they claim that it was self-defense for battery that occurred in the past. So this is often really hard to prove because there's no imminent danger at the time the force was actually used. So a lot of courts will not allow women or battered children to claim self-defense because there's no imminent injury or damage at the time where they use self-defense. So what do you think about it? So one of the arguments against it is retaliation as opposed to defense is a common problem in cases arising from wife battering and domestic violence. The injured wife waits for the first possibility of striking against a distracted or unarmed husband. The man may even be asleep when the wife finally reacts. So where if you do the analysis, you're missing that imminent danger thing at the time. Without that, you don't really have valid self-defense. So I just want you to think about that. What do you think about that? Do you think it should be excused for battered women or battered children? Okay, so the last thing I want you to do is start to look up self-defense in the New York penal law. So I have posted a series of 4 problems, practice problems, where I want you to look up in the New York penal law and see what New York says about self-defense. So first, I want you to look up section 3515. It's important to know section 35 is called use of force. So a lot of times if you become a police officer, you have to be trained every year on Article 35. And so even though it applies, and it's what force police officers can use. And although the police are trained on it, it also applies to different people. So it's all use of force. When can you use force? So look up 3515 and decide, when may a person in New York use physical force to defend a person? So physical force. Now look under that same section and figure out, when in New York can you use deadly force? And then under that same section, when do you not have to retreat? So all those things are all contained in section 3515. So make sure you know the answers to those 3 things. The next question is 3510. Who is allowed to use a reasonable degree of force without being considered an initial aggressor? So there are certain situations where somebody can use force, just reasonable force, not deadly force. They can use reasonable force to do something without being considered the initial aggressor, even if they're the first one to use force. Okay, so I'll give you a hint. Do police officers have to wait to be harmed before they can arrest or touch or restrain a person? No. Okay, so there are situations where it may be reasonable for somebody like a police officer to use some level of force, even if no force was being used against them. There's a list of people, so make sure you look at that list. Under 3525, can you use physical force to protect property in New York? So we kind of talked about this with the spring-loaded gun. So first, this says, can you use physical force to defend property? And then, are you ever allowed to use physical force to resist an arrest? And I even gave you a hint, 3527, you'll find the answer, okay? Now, the next thing I want you to do is just to review everything that we did. So I'm going to give you 3 scenarios. You read through each of the 3 scenarios and you decide which of the 3 justification of defenses would apply. So remember, we only talked about 3 justification defenses: necessity, consent, self-defense. So read the scenario and decide which one of them would apply. So read them through. Write them down. When you're ready, start the video again, and I'll show you the answers. So hopefully you got those right, okay? So we are all done with justification defenses. We're done with chapter 5. So now you're ready to do chapter 5 assignment. Please, please, please print out that self-defense analysis sheet so you can go through all the parts of the analysis. You need to explain every step in the analysis for your answer. And then there's a couple other quick questions. So you have the rest of the week to do that. Please participate in that. There's also a discussion for chapter 5. So please participate in the chapter 5 discussion. Okay, so that's all I have for this week. You're done with chapter 5. Next week, we'll move on to chapter 6 and we'll keep talking about defenses, but we'll move on to the excuse defenses. Have a great day and I'll see you next week.